Good morning. Good morning, everyone. We've got a full house here and some people upstairs on the fourth floor and a lot of information to convey, so we want to try and stay on time as best we can. Thank you, everybody, for taking the time to come to this program today. My name is Helen Bernstein. I'm Counsel Program Development in the Department of Professional Development and Competence at the Law Society. We want to welcome you to today's very first Real Estate Law Summit, the first of what we hope will be a series of program year after year. We just have a few reminders before we get started. Program attendees are eligible for the Law Pro Premium Credit. Just look inside your binder for further details. And we also want to remind you that this program has been accredited by the Law Society Real Estate Law Specialty Committee for 11 hours towards the professional development requirement for certification. Materials for day 2 are not in your binder yet. You'll get them after lunch. We hope you take the time to fill in the grade course evaluation form, and we want to remind you that the program is being videotaped. Finally, we want to thank our chair, Sidney Troister of Torque and Main's Cohen Arbus, a prominent member of the real estate bar who really needs no further introduction, as well as the members of our faculty for all their efforts in making today's program come together. I know that you're all in for a very interesting 2 days. I'm pleased to turn the podium over to Sid.
Good morning, everybody. I'm delighted to be the chair of this 2-day event that I suspect is going to become an annual event, and judging by the turnout, I suspect it will become one of the premier real estate continuing education programs that is offered every year. I want to tell you a little bit about how a program like this gets started so that you understand what a little bit of the thought process is. Law Society Helen called me a number of months ago with this idea about doing something called a real estate forum or a real estate summit. She said that in Minnesota they do this, where they, every year they have this annual event with 2 days, and they bring everybody together and they really blitz the law and blitz practice, and it's very successful. And she said, we'd like to try to get it started in Ontario, and how would you like to be the chair? My first reaction was no, not interested, maybe for next year, but what I said was when we did the special lectures, and most of you know about the special lectures last year, it took about a year to put that program together because it was very much focused on law and making sure that we had the best of the best by way of speakers, and really we fine-tuned that program knowing that it was highly unlikely that the Law Society would get around to special lectures in real estate for another 30 years. So I said, no, I'm not interested. It takes too much time. And she said, don't worry about it. We'll do all the work. All we want you to do is come up with the ideas for the program. So I decided, okay, maybe I'll take a crack at it. And this is how a program gets started. You decide all the things you don't know but you want somebody else to answer for you. So I said, what don't I know, or what have I been faking for all these years? And that's how you come up with topics, because it's really very personal to me. And judging by the turnout, I see that you also have been faking it and also have exactly the same questions that I do about what it is we do day to day. So hopefully this program will answer my questions, and if it answers your questions, that's good too. But like I say, I'll be selfish and say it's my questions that I want answered. A couple of housekeeping things. Your materials, I think, contain some stuff about, I've been asked to talk about this, I don't get a piece of this action either, about the specialist program offered by the Law Society to be certified as a specialist in real estate. It is a new program. People have been waiting for years while the litigators and the construction lien people and the estates people and the family law people all get certified, and the environmental people all get certified. We poor real estate lawyers, they didn't know what to do with us. I have a theory about that. And that is because they don't understand real estate and they don't understand what we do. It was very difficult for them to figure out what kind of standards should be imposed on us. But in any event, they've started this program, and there is material so that those of you who are interested in applying for your specialist certificate, I think there's a desk out there, and there's some materials. Go ahead and do it. I should say I filled in that form, and you would be surprised when you go out through the checklist to discover how much you know and how much experience you've actually got, even though many of you may consider yourselves, by no stretch of the imagination, an expert or whatever. When you go through the checklist and you see all the things you've actually done, you'll see that you may very well be well qualified. Second housekeeping thing, the Bar Admission course is looking for instructors for the Bar Admission course. That is being offered this year between about May 15th, May 12th, and the end of May. If anybody is interested in being an instructor in the Bar Admission course, the nice person to call is Anne-Marie Darlington, who's also sitting over there, and she will be happy to tell you about what's involved. I should say, as somebody who was involved in the Bar Admission course for a very long time, I highly recommend it to you for a couple of reasons. Number one, you get the materials. Number two, you actually figure out or learn maybe some of the things you're doing right, which is always a great affirmation, and maybe some of the things that you could be doing better. And third of all, there is, and this is from my personal point of view, the most important aspect of it, and that is you get to hang around for about 2 weeks with other real estate lawyers and trade notes. And if there's one thing I find in our business, we don't talk enough to each other to find out what we're doing. And in Bar Admission course, as an instructor, there's a daily meeting, and you get to talk about problems and figure out and find out what other lawyers happen to be doing. So it's a neat exercise. Sorry this is taking as long as it is. This afternoon, there was a panel called Ask the Experts. The goal of that is to give you the opportunity to ask the questions that maybe some of the speakers didn't answer for you today, or to just fire away at will. There will be Natalie Vukovich, the leasing lawyer, Donna Shier, the environmental lawyer, and two run-of-the-mill lawyers. They're not really run-of-the-mill. Steve Pearlstein and Leor Margulies. So among the four of them, there will be a wealth of experience and a whole range of topics for you. Tomorrow's panel, I just want to give you a heads up on that. Tomorrow's panel, I hate panels, frankly, but tomorrow's panel should be neat because we're going to be talking about that difficult question about what do you do when the deal is starting to go south. And on that panel, we've got mild-mannered Paul Perell, who's going to be the moderator, trying to keep 4 lunatics at bay. There'll be 2 litigators, Stephen Brunswick and Allan Sternberg, and if you've ever heard those two guys talk at each other, you'll know that anything can happen. And then, of course, Reuben Rosenblatt, who doesn't let anybody get a word in edgewise, and me. So it should be fun. It will be a bit of a fishbowl, and it will also be participatory for the audience, so it should prove interesting. Last housekeeping. The evaluation forms. The evaluation forms are more than just that. If you think of any topics for programs that you would like to see at next year's summit, as weird as that may be, please also hand those in. If you would like somebody to speak on a particular topic at a continuing education program, then put it down. All the ideas don't have to come necessarily from the organizers. And lastly, there is a nice cocktail party this afternoon. Please come. We don't get a chance to hang around and talk and shoot the breeze as much as we probably should, so you're all invited. It doesn't cost anything, and we can talk. So, on with the program. Depending on when you were called to the bar, you learned your estate conveyancing from one of four people. Mr. Justice Howland, if you were in bar admission course in the early 70s and before. Miriam Kelly, who tried to take Howland's lecture and turn it into something that was comprehensible. Then after she did a great job, we tried it again with Max Marichaux, I think, and I think his is the most recent paper in the bar admission course materials. In any event, we all know what estate conveyancing is. It's that chapter in the book that we look at when we've got to figure it out and learn it all over again. Ian Hull is going to speak to us about estates and how estates are affect real estate and vice versa. Ian is an estates lawyer. He is not a real estate lawyer. But in the course of his practice, he is regularly being consulted by real estate lawyers as to how in the world a piece of property can be conveyed when there are estates problems in the chain of title or in the grant itself. Ian.
Well, thank you very much. I am the proverbial fish out of water here today, so I have my own source of water over here. And I couldn't help but notice, having been to a few estate seminars, the difference in coming to a real estate summit such as this. One that stands out is the great turnout and the tremendous interest in what is going to be a great 2 days. And the second is the freebie. We don't get freebies at estate seminars, so getting to take home a mouse pad is pretty cool. Real estate conveyancing is all about rules. And then you add in the element of estates, and you have more rules. You add in the element of electronic conveyancing, and you add in new and more rules. I personally have to suffer through lots of rules at my own house. I have a 9-year-old fixated child over hockey, and last night as I walked in 2 minutes into the first period a little late, he told me the new rule in the house is whenever possible, please say whatever you have to say during the commercials. So I've followed that rule dutifully for the rest of the game and personally enjoyed the results without showing any bias. The second rule that I'm struggling with with my wife is, of course, as a good litigator, she and I have created rules with our own arguments, and one rule is anything that we said 6 months ago is inadmissible in any argument. And then the one that I created and then sort of fine-tuned was, in fact, actually all comments made after 7 days are null and void. So I've got my own rules, and I'm trying to focus them in the context of real estate and estates. There's lots to consider. I'm going to just touch on a few topics today. I'm going to talk a little bit about vesting issues, talk a little bit about the role of the Office of the Children's Lawyer and the unique circumstances when dealing with them, touch on a few electronic conveyancing issues, and make some comment on the real estate checklist that I've created and adapted from various sources. Conveyancing in estates is all about who has authority to deal with the property. We have an owner who is dead, and there's a consequence to that death, and we have to consider those consequences in moving forward. Starting with the fundamental concept of vesting, the statutory rules and the case law review is set out in my paper, but from a practical standpoint, for a variety of reasons, real property owned by the deceased can and does remain in the estate for some time. I'm going to just stop for a moment and apologize that some of the terminology as I move forward will be I'm going to use the term executor, I'm going to use the term probate, just because I like them better and they still have a statutory authority behind them. But I will throw in the estate trustee during litigation and with a will and so forth, just so that you think I've read the new rules. The general rule with vesting is the first 3 years, real property and authority is under the control of the executor. Section 2 of the Estates Administration Act says that all real property vests in the deceased at the time of death and devolves and becomes vested in his or her personal representative. And that's despite any provision, contrary provisions in the will, and even if the property is directly given to a beneficiary. Now, with all rules, we have exceptions. And the first exception is one that we all know well, and that is that that rule is subject to joint property and passing by survivorship. I have some comments on some exceptions to that a little bit later. And then the other exception is that to the 3-year vesting rule is that Section 9 of the Estates Administration Act and Section 10 will govern after the 3 years. So let's deal with the exceptions. The first exception being the jointly held property. And it's a typical scenario in an estate administration, and that is there's a transmission application. It's a simple process. The things I like to remind my clients to watch out for, though, are additional tangential issues that may arise. For example, claims of resulting trust, constructive trust claims, claims of proprietary estoppel, more novel claims that are going to attach to the property. And in part, when you're acting for an executor and you have real estate in the estate, you don't necessarily want to move too quickly, and they've given us 3 years, and sometimes for estate lawyers, 3 years isn't even enough, but they've given us those 3 years for a reason. It's the old rule that, and it continues to prevail, is you have 1 year to administer an estate that is, it can be complicated in situations where you have additional tangential claims such as resulting trusts and so forth. The other key to watch out for is the whole concept of whether or not this joint tenancy, which on the face of it looks clear and should pass by right of survivorship with a simple transmission application, has been affected by any conduct or anything that would have resulted in severing the joint tenancy. I included in my paper reference to an article written by Jordan Ayton in the Estates and Trusts and Pensions Journal, where he goes through a much more comprehensive analysis of this issue. But I like to remind my clients that never presume that, without some investigation anyway, that the property is indeed jointly held at the date of death, and particularly where there are circumstances with a separated spouse, because possibly, intentionally or inadvertently, a tenancy in common does get created. The rule is, of course, that if jointly held and it's not severed prior to a joint tenant's death, the property is thereafter transferred, is thereafter owned by the surviving joint tenant. And that's to the exclusion of beneficiaries and heirs at law. Now, if it is severed, the tenancy in common results, and the deceased's share falls into the estate or on an intestacy, depending on the circumstances. But it's useful to consider when joint tenancy can be severed, and it can be severed in 3 ways: by unilateral conveyance of the property by one of the joint tenants; secondly, by mutual agreement of all of the joint tenants; and thirdly, and most terrifying from perspective of the real estate side of things, it's by a course of conduct, indicating the joint tenants' mutual intention to treat the joint tenancy as severed. And that course of conduct exception is something that I like to keep in mind when considering what I would have thought was starting off to be a very simple transmission application. The course of conduct, as I say, this article that Jordan wrote goes into great detail into this issue, but you need mutuality of intention. You need both joint tenants openly and mutually treating the tenancy as a tenancy in common. And this is typically done by written agreement. What doesn't sever joint tenancy, interesting enough, is of course a separation by the parties. Some clients presume that is the case. Divorce, commencement of a family law proceeding does not sever the joint tenancy. I want to turn now to the more common exception to deal with, and that is we have the 3-year rule, the vesting rule for 3 years, and the role of Section 9 and 10 of the Estates Administration Act. We've got 3 years to do something. We've got authority. We've got control. Section 9 of the Act, the State Administration Act, says, though, if property isn't disposed of within 3 years, it automatically vests in the person's beneficially entitled. You don't need a conveyance by the executor. You don't need probate. There's that word. You don't need, what you have is a shift in control from the executor to the beneficiary. Now, like all good lawyers, we have to have exceptions to exceptions, and like good tax lawyers, we would lose the second or third exception as we go along. But as an estate lawyer, I try to keep my exceptions straight. And the exception to the automatic vesting rule is, of course, that we can register a caution. And I always like to remind my clients that I'm only going to give them another 3 years. This caution last beyond the 3 years after registering it. And Section 10, if I have a trust will, is there is no automatic vesting. So stepping back to first principles, I've got authority, I deal with that. I've got the question of vesting under control at some level. And then the third question I have to ask myself is there a power to convey? And remarkably, that comes up. Obviously, most obvious is the concept in the context of an intestacy, but a poorly drawn will or a holograph will, sometimes you're faced with a situation where you may not have power to convey the property to a third party. And the necessary powers to convey that are contained in the will, I deal with it a little bit in my paper, and the courts bend over backwards to find language that gives them a sense that there is at least an ability to power to convey. And in fact, it goes so far as, as authority for the proposition that where the will provides that the executor is to pay the debts, that's sufficient for the power to convey. But if there's a will, then we can look hard, and typically we can find a power to convey. If there's no will, then the Estate Administration Act sets out the process. Section 16 of the Act gives the personal representative the power to dispose of or otherwise deal with real property. Section 17 allows for the sale, the payment of debts, the distribution to beneficiaries. There's restrictions in terms of majority of persons entitled and so forth. But there's a framework there. We've got this general rule that the power to sell property may be express or implied, and there are statutory protections to ensure that it can happen. Where this comes into play most dramatically in my practice is when you're dealing with the Office of the Children's Lawyer and minor child interests in property. And I put in my paper, and the Children's Lawyer's Office will probably kill me for doing it, but they have a great manual, and I've given you the phone number to call if you're interested in getting it. And they do encourage it, actually. I am saying in jest, because they have a terrific manual they put together with the forms, the necessary affidavits in support that they typically require and that the court will typically require when you're having to deal with a minor child's interests. Section 17 specifically speaks in the Estate Administration Act, specifically speaks about the ability for the Children's Lawyer's Office, and the Children's Lawyer, to assist an estate trustee who does not have the power to convey on behalf of minors, mentally incapable, and non-concurring persons. A minor is an easy definition. Mentally incapable persons is pretty straightforward. There are some twists in terms of who has authority there. The interesting one is a non-concurring person, and I sort of put my middle child in that category, but the residence is unknown and it's inconvenient to require concurrence. Those are the parameters. Obviously, the purpose of the Act, the Estate Administration Act in this regard, is to give protection to the executor, give the power to sell, and it sets out a specific statutory scheme to follow. The duties of an estate trustee without a will, or an estate trustee with a will with no power to sell real property, are the same. We've got to collect in and realize the assets, pay proper debts, and distribute to the beneficiaries. The twist is, of course, when you have a minor and you have proceeds, that those payments are typically paid into court and are paid into court. The sale of real property generally, though, with minors is the Children's Lawyer's Office, when dealing with them, they may approve a sale of an estate administration if the estate administration is not completed. If the estate administration has been completed, you need to go under Section 59 of the Children's Law Reform Act and bring a separate application. A lot of this is all dealt with in this handy manual that gets that their office will put out. And as again, I think I encourage you to get a copy of it and have it in your library as a useful resource when you're going to get into situations which may be a bit unique but are important to deal with. I want to make one comment on avoiding probate, and that is, as an estate lawyer, we will spend a half a morning on ways to avoid probate fees and enjoy it and bring great thought and consideration to the issue. Obviously, from a estate planning point of view, with registry, the certificate of appointment wasn't required. Under land titles, we have the first dealings. Under land titles, the property is brought in from registry, then we don't require probate. All I can say on that issue is that it tends to be a fixation with your clients, my clients anyway, that we do everything we can to avoid probate, and it is a useful discussion to have with your client in the estate planning process. I want to just turn to electronic conveyancing issues. And I sort of look at the electronic conveyancing issue and the new regime that is in existence as similar to the wills practice. And why I say that is that the most dramatic change that has occurred with electronic conveyancing is the use of law statements and our ability to rely on them. The onus is on the lawyer to essentially document the process. There's increased obligations on the lawyers to fully document the basis upon which you made the law statement, and most importantly, to preserve that evidence. Much like a will, where I'm required to take careful notes, and at the end of the day, somebody's going to say they weren't sufficient and they weren't as extensive as they should have been. On a real estate deal, the same kind of criticisms are going to be lodged at us when we're on the hook for the lost statement. And the most important criticism, the most important defense to any of those criticisms is what your file contains. And essentially, we've been pushed into a regime of holding on to much more documentation in the real estate context than we were before. The old way, I'll use the transmission application as an example. The old way, we got our notarial copy of the certificate of appointment, death certificate. We had an affidavit of application attesting by the applicant attesting whether the property was subject to debts, and we were off to the races. Now we've got a transmission application, which is a fairly straightforward process. We've got to make our law statement, though. We've got to put in our date of death. We've got to say that the applicant is appointed estate trustee, court file number, whatever, and that it's still in full force and effect. If there's no certificate, we have to talk about confirm that the value is less than $50,000, and we have the same subject to or not to debts provision. All of those look on the face of it as fairly innocuous. The problem is, again, we come back to the same thing, is it's our onus, and we're going to have to be verifying the law statement we made at some point in the future. So the date of death, that's simple enough. I make sure there's I encourage that a notarial copy or original copy of the death certificate remain in the file. On the concept that we have to say that the certificate of appointment is still in full force and effect, I remind people that, if you're taking over a file that you didn't get probate for, you may want to look behind that probate a little further than normal. You may want to make sure that that is indeed in full force and effect, and that some crazy litigator hasn't gone out there and revoked the grant, and there's an order in there, and that you're relying on a photocopy of a will that you thought was entirely valid. We have to, in the law statement, deal with the whole question of if the estate is less than $50,000 and verify that in the subject to debts clause. Again, what I do there is I encourage that put an affidavit together in the same form you would have in the old regime. Throw that affidavit in the file and maintain it in your records. So you've got your client swearing that, and that's the evidence that you relied on to make the law statement. These sorts of transfers by personal representatives can be problematic, and in any event, internal documentation is your evidence in support of your law statement, and I think it's now incumbent upon us to preserve those files, and there's always a long-standing debate in the estates world as to how long you have to keep your file, how long do you have to keep your notes, and the short answer is forever, and no one likes to hear it, and it may well be that that's the regime we're faced with in a real estate context, so that the law statements can always be supported by the documents in the file. That's an aside, and something that you and the real estate bar will debate, but I know that it's a tough decision in the estates bar as to what we do with our files in the future. The last point I want to make, just to note, is that I have an estate conveyancing checklist. It's not the be-all and end-all, but it seemed to me anyway as a useful starting point when we get into an administration to walk through if I've got an estate which has real estate in it. It's a summary of the more comprehensive checklist that's found in the Canadian Estate Administration Guide, which I encourage you to work through and look through. But it's helpful. I mean, there's things, for example, on a partition and sale application, Section 3, Sub 2 of the Act says you can't bring one within 1 year of death of someone before, you have to wait 1 year after the death before you can bring a partition and sale application. Trust ownership issues. I mean, the registration of in-trust property does not affect the ownership unless the purchaser has actual notice of the trust and there's authority to that effect. Those kinds of reminders that I think can be useful when you're working through an estate administration with real estate in it. Anyway, I know you've got 2 days of interesting topics to cover, and I hope that I've been able to at least go through a few topics in the state administration area. Thank you for your attention.
You can't have a continuing education program for real estate lawyers without electronic registration being a topic. Rosemary Grenside is part of this program because of her background when she was, frankly, at Osler, Hoskin, and Harcourt. Now, I will assume that many of you here are not members of the largest of firms, so I'm going to let you in on a little secret. And I hope that if anybody is from one of the larger firms, they don't take offense. The largest firms, when E-Reg came out, got together and formed this little club called I'll use my words, the Big Firm Special Club to talk about E-Reg that everybody else isn't going to be a part of. When we talk about big firm, we're talking about big firm. And Rosemary was then part of a big firm, maybe the biggest firm, and she was on this committee. And as it turns out, a subcommittee was formed, which was called the Big Firm Special Club for Law Clerks who do E-Reg and all want to get together and talk. And Rosemary became the chair of this committee because she had formerly been a law clerk and then went back to school, became a lawyer, and has practiced in real estate for the last, I don't know how long. But she, better than anybody else, as far as I'm concerned, understands E-Reg. I am proud to say she's now a member of Torque and Mains, which is not one of the members of the big club. But now that she's a member of our firm, we're in the club. Only by virtue of inheritance. But Rosemary is going to tell us all the things that you can and can't do in E-Reg, but we're afraid to ask. Thanks.
Well, I hate to crush, well, actually, I guess I like to crush some of the things that Sid says. He's right in part. It was a large firm effort that started the getting to understand. E-Reg was in Middlesex, and here we were in Toronto, and we just didn't know anything about it, and it was coming. And so we felt we needed to get together. And that was the beginning. However, many smaller firms, and firms smaller than Torque and Mains, have joined that club over the years and have made it a very useful venue for being able to meet with the ministry and meet with Teranet and get some of our issues addressed and so forth. The law clerks user group also consists of a number of law clerks from smaller firms, and so that club has, from the beginning, has been quite broad, and it's an extremely useful group. We meet every 2 or 3 months, and I would recommend to any of you who are dealing with E-Reg on a fairly frequent basis, if you're not involved with a user group, whether it's a lawyers group or a law clerk group, that you become involved and you can create your own. It's a very useful tool to be able to chat back and forth as to how do you do this, and have you done one of these before? And as a group, you will have more impact on the ministry and Teranet in making changes, and that's certainly something that we've been doing over the years. Before I get into my presentation, I'd just like to make one administrative comment, and that's on page 2 of my paper, which I only submitted last week. But the last line just above the heading, a basic transaction, I refer to Bulletin 2004-01, and that has already been revoked. There was just a minor error, typographical error, which is probably self-evident, but in any event, the new bulletin, and if you just correct your notes in there, is 2004-04. I wanted to back up before we get into electronic documents and just give some background. I chaired the third annual Law Society program for law clerks in real property on Monday, and John Dalgleish from the ministry spoke to us, and I thought you might be interested in this fact. Over 3.9 million properties are now in Polaris. That means they've been automated. Not all have been converted, but those have been automated, and the ministry expects another million. So we're going to have just under 5 million in the TerraView database once conversion and automation has been fully completed. At present, the ministry estimates that to be 2007, maybe spilling into 2008. Also, by way of background, when we started this process, or before starting this process, we had two systems. We had the registry system and the land title system. And some of us played more in the one system than the other. But that's where things were. And the land title system, on the whole, dealt with absolute title. As a result of the automation process, which requires these parcels to be put into a computer system, registry properties have been converted, and they are known as land titles conversion qualified parcels. They are land titles parcels. They are subject to Section 44 of the Land Titles Act, which lists all of the various exceptions, such as Planning Act and dower and taxes and a variety of things. However, during that process, they were able to eliminate some of those qualifiers, and those exceptions are stated in the parcel. And so they were able to eliminate prior contraventions of the Planning Act and any escheat and forfeiture issues. However, there's an additional qualifier, and that is that adverse possession is still an issue, and this is because no notice has been given to the owner or adjoining owners. So we now have the land titles absolute, we have the land titles conversion qualified, and if you have a conversion qualified parcel and you would like to have that additional qualifier removed, the adverse possession one in particular, removed, you may make an application which is referred to as an LT plus application. It's a much more simplified application. You don't have to go back. The ownership aspect has been dealt with, but it's a process whereby you can deal with the adverse possession issues. So you will have to look on your parcels and make sure you know whether you're dealing with a land title. So you look at the fee, the estate qualifier, fee simple, whether it's absolute, land titles conversion qualified, or LT plus, and that will tell you what sorts of searches you need to do. Other than that, you're in land titles regardless, and when your registry office becomes mandatory, you'll be using electronic registration. Through this process of conversion, there are a number of things that have happened. One is very messy parcels. You will find that things were brought forward that ought not to have been brought forward, and perhaps instruments that should have been brought forward that weren't. And you may also find what is known as a non-convert. A non-convert is still a registry system parcel, and it hasn't been converted for a variety of reasons. Quite often it may be that ownership cannot be assured because there may not have been paper title, there may have been a Planning Act contravention, and those systems will remain in the registry system. There's no obligation on anybody to convert a non-convert parcel. The ministry may do it at some point later on if they find evidence that allows it, but registry parcels are still acceptable. And of course, if you are using a registry parcel, even though it may have been given a PIN, you will not be able to register electronically. You will register it by paper. If you want to get your non-convert converted, it's again a relatively simple process, and I refer to the bulletins in my paper, which will guide you through that process. And those things are really depending on you and your client. I certainly found in a situation with one of my clients where we were buying from a railway, and often in the old days, in the 1800s and so on, the railway just didn't register their deeds. And by the time we hit the 21st century, nobody could find those deeds. We were satisfied as to possessory issues, so we weren't going to force the conversion of that title prior to closing. But once we got a deed and we registered that deed on title, it then made it very easy, and we made the application because we now had the deed showing our client as the owner. So you may decide to do your conversion after a transaction. As far as messy parcels are concerned, they come in variety. Sometimes there's just the odd thing there that you think just isn't right, and other times the whole thing, you wonder, where did they get this? Quite often the latter is as a result of a complex registry transaction that took place prior to conversion. The ministry gave guidelines to Terranet on what procedures to follow in the conversion process, and so they were not to look at deposits, and they were not to look at certain instruments. So in certain cases you can understand why, where we dealt with things in the registry system by putting valuable information in deposits as to the status of the title. Those things weren't looked at. But you can still get those, or you may have documents in your file, and you approach the land registry office, the relevant one. You find out why, if you can, what's going on, and they will work with you. Sometimes it may be a matter of an exchange of letters between you and the registry office. That'll be the case where it is obvious that Terranet made a mistake when they converted. In other cases where you're just not happy because something you think should be there, but it may be that it was in a deposit, they will ask you to do an application. Quite often the fees will be waived, not your fees unfortunately for doing the work, but the registration fee for the application will be waived, and the applications aren't even registered on title, but it's part of the registry office files, and they have to use that for an audit trail. I'm going to turn now to some of the documents. Within the E-Reg system, one of the things that I first found a little confounding was the land transfer tax affidavit, and how was I going to electronically make the statement that somebody had in fact sworn the statement. That is now gone. Affidavits for land transfer tax still exist in the paper system, but as of the last version of Terranet, they are now referred to as land transfer tax statements. And there is a tab when you look, and it'll say deponents, but in fact there is no oath language, and whether that tab name will be changed or not, I don't know, but it needn't throw you. In recent versions of TerraView, we are now allowed to sign statements on behalf of the transferor. That has been allowed in the paper system for some time, but wasn't originally in the E-Reg system. The requirements are that the transferor must have sufficient information to make the statements. There must be no consideration for the given transaction, and the transferor must be the one who is tendering the document for registration. As you know, with a transferee, solicitors or agents can make statements on behalf of the transferee. With a transferor, however, it must be the transferor's statement. A solicitor or agent for the transferor is not available. Claim for lien, that is not something that I have much experience with, but I did deal with Paul Ivanoff at Osler's, who is very involved, and Roger Gillett, who are very involved in those areas. Roger Gillett is with the construction law bar dealing on a regular basis with the ministry and Terranet to get documents changed. One of the main concerns, certainly initially, is that the affidavit of verification, which is prescribed under the Construction Lien Act, is a set of statements. that you make electronically, and then who's making those statements, who's going to be cross-examined on those at discovery. I'm not going to go into that, but in my paper I did list the main paper that Roger Gillett wrote a number of years ago, 2001, detailing those issues, and he's also written subsequent papers, and all of them are published in various venues, and the sites are there. There's also a case now, the first case on the electronic registration of a construction lien, and that's Petrov Partnership, and the site is given to you there as well. Powers of attorney. That's one that slipped by for a couple of years, I guess, and then we all started wondering about it. I have shown you I've tried to do a picture in my paper of the statements that are there in a power of attorney. I think it may be on page 14. And you'll see what's there. We're used to powers of attorney either under the Powers of Attorney Act or the Substitute Decisions Act, and there are a set of rules that one must comply with. The power of attorney form that's in E-Reg, at first I didn't honestly know what it was. I didn't know whether it was creating the power of attorney or whether it was just the vehicle for me to somehow deposit notice of a paper power of attorney that I had. But there are a number of issues that are of concern. If a paper power of attorney already exists, and it's registered in the system already, there will be a GR number for it, and you can still refer to that. If it hasn't been revoked, it's still a valid power of attorney, then you can make reference to that in any instrument that you're registering on title. If a paper power of attorney exists, but it hasn't been registered on title, now you have to think about what you're going to do. Some will take the E-Reg power of attorney form and will click one of the first three statements and mention who the donee is and so on. And then as the schedule, they will attach the paper power of attorney and scan it in, and then register that. But the question is, if the original power of attorney does not provide for multiple continuing powers of attorney, then by clicking this statement, I appoint the donee as my attorney to act on my behalf, are you revoking the paper power of attorney that you have? So as a result, a lot of lawyers that I know are not using the E-Reg form of power of attorney. The ministry has agreed that even in mandatory offices, you may still register powers of attorney by paper. If you're not going to do that, you want to use the E-Reg system because it certainly is more convenient in many ways, you'll have to consider those issues. If you don't have a power of attorney at all, and you now need one, is it sufficient to simply use the E-Reg form? If your client signs the acknowledgement and direction, is that sufficient to have created a valid power of attorney form? Would you get two witnesses to witness the signature on the acknowledgement and direction? Again, I don't know. At this point, because the ministry is allowing paper registrations of powers of attorney, I would much prefer myself to use the paper form, ensure that compliance is had with the Substitute Decisions Act, and then register that in paper with the registry office until this issue has been resolved. It is one of many issues that the ministry and Terranet are looking at. They have what I've been calling a wish list, where users have complained about certain points and they will try to address those points. I think John Dalglish from the ministry refers to it as stakeholder needs. But it's a very, very long list. We all have our grievances and gripes as to the system, why it doesn't work and how it should be fixed. They have kept a record of all of those, and the Joint Committee, Law Society, and the Ontario Bar Association as well is very much involved in this. The list gets prioritized depending on a variety of factors, one of which would be the number of users that are requesting a change, and of course the system capabilities. And that system capabilities translates into cost to some extent, cost to fix. Some changes are made via downloads that you can get from the internet, and you simply download them or get your network people to arrange for that. Others are actual upgrades to the system when it's more involved, but changes are being made all the time. Leases. It's another document. The lease originally was a two-party document, which didn't jibe with the way we were doing that in the paper system. Usually the landlord alone wanted to register the lease if he or she was doing financing, or the tenant would want to register notice of their interest in the lease. But very rarely would you have both wanting to register. So initially it was a two-party document, which would mean that you'd have to get an acknowledgement and direction signed by both the landlord and the tenant, or get two lawyers involved and both be doing it. As a result of complaints from user groups, the lease has now been changed to a one-party document. I'm still not happy with it, and continue to want changes. It's complicated. If you're registering a lease for a landlord, it's probably relatively straightforward. The landlord will be the party from. You will list the tenant as the party to. The landlord can make the statements, the land transfer tax statements, and register the document. If you want to register for the tenant, you really need to override the pre-populated part of the party from, which will automatically show who the owner of the property is, and put the tenant's name in there. And after that, you make a decision as to who's going to be the party to. You can't leave it blank. It'll either be the landlord, or you might put the tenant in again. If you don't put the landlord in as the party to, you will have to make reference to who the landlord is or who the owner of the property is at some point, probably in Statement 61. But when you register, you've got a rather unusual scenario where the parcel is showing tenant to landlord or tenant to tenant for notice of lease. And so, as I say, I don't like that system. I'd rather the lease was done as an application to be registered by either party, and either party would indicate who they are. Again, as a result of the various complaints, the ministry will still accept paper for leases. And so if you feel that you just can't fit within one of these, or you don't like the way the parcel is going to look, you can still register in paper. Compliance with law statements. Initially, this was, my understanding was that these were going to be solicitor statements. Only a solicitor can make compliance with law statements. Clerks and assistants cannot. And the types of compliance with law statements that I visualized were that the transaction didn't contravene the Planning Act, that the sale proceedings and transfer complied with the Charge and the Mortgages Act, that a court order was in full force and effect, those types of things. But as Ian referred to earlier, and as in his paper, there are a number of what I would call purely factual statements, and sometimes mixed fact and law. And again, I would reiterate what Ian said on these types of things, whether it's the date of death or that the debts of the deceased have been paid. Sometimes it's dealing with a writ. You must have the backup, and you must keep that backup in your file. Brian Bucknall and Maurizio Romanin did a presentation and have a paper on the compliance with law statements from a program with the Law Society in November of last year, and I've given you the information there. A couple of other little things. Be prepared. Every once in a while you will find some offices react differently from others. We recently had a situation with a committee of adjustment where they would not stamp our e-reg document. They insisted that we use the traditional paper form. And that's what they were used to, and they wouldn't do it. The Ministry of Consumer and Business Services and Terranat don't have any control over the regional municipalities, and it's just a matter of trying to get to perhaps the solicitors for the municipalities and the regions to try to get them to change, but there are those inconveniences. Other kinds of things you'll find where properties are registered, were registered in land titles and in the registry system because your client-owned property in both systems, you would have numbers. The RO number 12345 and then the LT number 54321. And you would frequently refer to both of those numbers. There's no room in the e-reg form to refer to both of those numbers. You may have to register 2 applications or 2 documents dealing with those. If you refer to the other number somewhere else in the paper, you may run the risk of, or somewhere else in the e-reg document, you may run the risk of it not coming off or not being dealt with in the manner that you want. So, in conclusion, I just want to say that during my time with e-reg, both at Osler's and now with Torque and Mains, I've had incredible experiences with the people at the ministry and at Terranat. They very much want to make this work, and so I would recommend, again, that you engage with others, get user groups together to help yourselves, and then also to be able to submit issues to the ministry and Terranat as you see that they need to be fixed. Thank you for your time.
I told you she understood e-reg. One other thing, just following up on what Rosemary said, she did talk about powers of attorney. I'm going to be talking about powers of attorney tomorrow in the context of what lawyers get sued for because, and we'll talk about it tomorrow, there's been lots of fraud happening with powers of attorney. When you look at the documents, you realize how idiotically simple they are and how we rely on them. And so we'll be talking about that tomorrow in addition to the whole issue about what you do with e-reg with a power of attorney. A number of months ago, the Law Society had their program, the 6-Minute Commercial Leasing Lawyer. I'd never gone to one of these things before, but I was speaking at it, and my reaction to listening to 3 or 4 hours of lawyers talking about commercial leasing is they don't live in my world. Because they were talking about how they negotiate roof repairs as between the big boys and girls and the other big boys and girls, and usually my clients are much smaller and don't have the same kind of bargaining power. They were also talking about things that that were brand new to me, and I recommend the book on the commercial leasing lawyer, the 6-Minute Commercial Leasing Lawyer, if you can buy it from the Law Society, because it has all kinds of wonderful things in it that I would never have thought about, like cable contracts and telecommunications contracts that are a whole brand new entity that landlords are dealing with regularly given changes in buildings. I grew up and I still practice in the world of square feet and walls, and that's the sum total of my leasing experience. In any event, Natalie Vukovich practices exclusively in commercial leasing for both landlords and tenants. She spoke very well, if I may say so, at the 6-Minute Commercial Leasing Lawyer, and we thought that she would be ideal to speak to us today. The hardest part of the job was to get Natalie, from my point of view, and remember these are my questions and not necessarily your questions, to dampen down the topic, to get a little bit more basic, and to talk about what we can realistically negotiate from a tenant's point of view when we're talking about net leases. Natalie.
Thanks, Sidney. Good morning, everybody. somebody once described to me the best way of dummying down a lease contract would be to get the tenant to put its hand over the photocopier and the landlord to put its hand over the photocopier and to have them photocopy their handshake and then just sign. and I actually think that's a lot of what goes on in leasing. My area of practice is indeed very specialized. There isn't even a specialty recognized yet on the topic by the Law Society, but there are a few of us. We tend to consider ourselves not members of the profession, but so much members of an industry. We belong to the shopping center industry, the office industry, and all we do is leases, leases, leases. You might find it hard to believe, but that's a practice all of its own. I act for people like Cadillac Fairview and Brookfield and Morguard, and the leases I negotiate are opposite tenants like Indigo, Williams-Sonoma, Whole Foods, and AGF. And so it is sort of stratospheric. On the tenant side, I got to represent the Law Society in an office lease negotiation they did for some expansion space up University Avenue, and I've represented the Karr, and I have sort of standing relationships with Rabba Fine Foods and with Zale, the people who run the Peoples and Mappin's Jewelers business. So I act for both landlords and tenants, and the people I negotiate opposite tend to go straight to the chase. We start a half a sentence. You already know what the rest of the sentence is like, so you cut each other off and you say, okay, let's resolve it this way. And of course, it's a volume type of practice. You can't possibly spend a lot of time on every lease. It's not going to make you any money if you're going to dig too deeply into every single lease. There are the odd ones that come along that are nice and fat. Most of them you skim along as fast as you can. So on the assumption that you guys are real estate lawyers who don't do a lot of leasing but do some, the organizers and I said we should try and make this part of the presentation geared towards sort of the average lease transaction, where the emphasis on the title here was net. And what we're really getting at is, what does a tenant want? If you're retained to represent a tenant in negotiating a lease, what does the tenant want you to do? We're assuming that you don't have a big budget for legal fees. We are assuming that the landlord, your opposite, might be bullyish and may say to you, what's your top 10? And then I'll pick the 5 of those top 10 that I'm ready to talk to you about. And if so, then your job is to really dummy down to what is most important for your client. Now, of course, when we say, what are you looking for in a lease form? The question is, are we looking at Walmart's lease form, or are we looking at Oxford's lease form? And your task is very different. But let's assume that you're looking at some average landlord's lease form with a relatively reasonable degree of sophistication. They're deal-minded. And your job is to try and trim the fat. In other words, protect your tenant client from excessive op cost abuses and other types of money items that will show up in a net-net lease. I'm assuming you all know what a net-net lease is. We're not talking about credit leases or gross leases or apartment leases. So in my paper, I've tried to provide a checklist of some of the items that you could run through, and I don't think I'm going to have time in 20 minutes to go through every single point. I also have to apologize in advance for the jumpy style of my paper, because I thought first I'd do point form. Then I would grab materials that I'd written somewhere else and find that they were in prose form, so I'd throw them in. Then I'd try and point form them and then abandon it. So I'm all over the place in terms of format. Also, the spell checking decided to correct me in a few places where I wasn't paying attention, so I should point out a typo on page 6, where I refer to, in the 4th line, I think it is own assessment-based. That's actually non-assessment-based taxes, something you likely won't have to contend with very much. Also, on the very last page, it says structural, when it should have said structured, and that's about the 2nd or 3rd last line there on the topic of relocation. So in the program materials, what you were told that I was going to speak about today were management fees and structural repairs and so on. So I'm going to try and delve into all the things that are on the program, whether or not there are a few other things in the paper. I'm not sure if we'll get to those. Management fees are a bone of contention often. Management fees are paid by tenants to landlords under net-net leases in a few different places. They can be found as tag-ons to a number of cost items. They can be in an operating costs pool. They can be in a general provision that says for everything the tenant ever pays, it always pays a management fee on top. Sometimes the management fee is called an admin fee. There's a tendency in the industry to have layering of people responsible for monitoring a property. You have the owner, who could be a pension fund. You might have an asset manager. You might have a property manager. And then, of course, there's the people on the site. And everybody's trying to make money. And the idea is that since the net lease is a flow-through, no one's making any money, it's just flow-through. But you've got to make some money along the way, so they attach management fees, let's say, to the asset manager or to the property manager. And they may also have admin fees on the theory that whoever is administering the property always has some extra effort and that there should be some profit there, and that you're not going to be able to just flow through the snow removal contract. You've got to figure that there's some effort involved in arranging for the snow removal contract. So now you see a tendency creeping into leases to weave in the possibility of both management fees and admin fees. Management fees tend to be in the range of 3 to 5% of all gross revenues. And 5 is still considered to be fairly high. 3 is acceptable. You may not be in a position to negotiate that if your tenant has already signed an offer to lease and it already says something on that front. Admin fees are in the range of 10 to 15%, and you find that grocery stores are generally in the 10% range. Governments are willing to pay 12%. Everybody else pretty well pays 15% unless you're a bully tenant. I'm assuming you're not representing that kind of a tenant. So the thing you should watch out for is where in the million places in the lease the management fee and admin fee will show up, and try to ensure that the tenant is responsible for paying only one or the other, but not both. I don't think you're going to have a whole lot of success in driving down the 15% admin fee, depending on who you're acting for. So you should just look for where it's reached for too many times. Most landlords will agree to one or the other, but not both. Structural repairs. Now here you have to distinguish between ordinary day-to-day repairs to curtain walls or loading docks. Somebody may drive a truck into a load-bearing wall and knock out a brick, and then that repair has to take place. Well, landlords mean that those types of structural repairs are going to be picked up, whether they're big ticket items or small ticket items, whether they're insured or whether they're not. Landlords intend to recover those costs under a net lease. Tenants shouldn't object to those costs because they're part of everyday management of a property. There are other types of structural repair costs that can be very expensive, though, and those would arise from defects. So those you should not be willing to pay for, and certainly there are ways of phrasing tenant not responsible for repairs resulting from structural defects. The tenant also should not be responsible for rebuilding the entire property. So maybe the way to do this is to just trim down the structural repair concept so that it is only dealing with ordinary day-to-day structural repairs. As to glazing, if you're in an office property, the question is whether the windows form part of the structure or not. And no one ever really talks about that. You just say structural. Many landlords go through a process of recladding their buildings after 30 or 40 years. And when they reclad the building, that is not considered to be a structural repair, nor is the replacing of the windows considered to be a structural repair. If you're aware that the building is old and tired and you're representing a tenant who's taking maybe 20,000 square feet of office space, it might be within the range of what you're retained to do to ask what is planned, and then perhaps to talk about spreading out those costs over some time so that they don't all fall into 1 year. I have seen landlords drop those costs into 1 year and practically kill the tenants. Depreciation has to do with what people usually think is a landlord's trying to create a sinking fund and trying to make money on its capital investment in the property. That's not generally what landlords mean, but they use broad language that would permit them to recover those costs if they had the inclination to. What it generally means is that there are some items in a property that have a tendency to wear out and require periodic replacement. And so those types of expenditures will get amortized over the period to which they relate. The CICA handbook doesn't even recognize the term depreciation anymore. They call it amortization. And that's to get away from the concept of it being a capital expenditure. Many of you are probably accustomed to throwing in the kitchen sink list of net lease exclusions that says, don't charge me for anything capital. That's a hard sell. You're not going to be in a position to get a landlord to agree not to charge you for anything capital. What you might get the landlord to agree, which it should agree to, is that it won't charge for the original capital costs of constructing the building or replacing the building or renovating the building, et cetera. But however, there will be HVAC replacement, there will be parking lot replacement, roof membrane replacement. Those items could be, or should be, you might even insist that they would be amortized over a reasonable period. And then when you amortize them over that period, you can expect that there will be an interest component. What you might want to try and do is make sure that the admin fee doesn't apply to the interest component of amortization, because that doesn't really require any effort. That's just a computer program that spits that out. Capital taxes. Most lease forms do call for the recovery of capital taxes. Some don't, and that's great if you don't have to deal with it. If you do deal with it, then just by way of brief background, capital taxes are the tax levied by, in Ontario, the provincial government, and in other provinces it varies, and of course also by the federal government on the capital that is held by a corporation. So the right side of the balance sheet basically is what the taxing authority looks to arrive at paid up capital, and then it applies a taxation rate. You would think that's a wealth tax or an income tax, but the argument by landlords is that tenants would have to invest their own capital in property if they were not leasing. And so this tax that is levied on the owners is one that should be flowed through to the tenants on the basis that it's really a cost of operating. You know what, don't even waste your time trying to convince a landlord they're wrong on this point, because they're either sold on the fact that they can recover it or not. Just try and strike it, and if you can't strike it, then ask how much it is. Because you might find, particularly if behind the line the landlord is a pension fund, that there isn't any capital tax, they just have it in the lease form. And you might then be able to work your way to an acknowledgement that the landlord is actually not currently capital taxable. If there is a capital tax amount, say it's 25 cents a square foot, then you might be able to knock that out, unless, of course, the offer nails you. If the offer already has a reference to capital tax, then you're going to be in trouble. But if the lease calls for a capital tax and it's 25 cents a square foot and you can't win the point, then what you might want to do is at least protect the tenant from escalations, because if the next buyer of the property comes in and invests a ton of money to improve it, the capital tax bill is going to go up. So you may say that the capital tax can only increase as a result of increases in the tax rate and not as a result of any refinancing or redevelopment by the landlord. Might try that. This will depend on bargaining power. Gross-ups. Everyone gets confused with gross-ups when they encounter them in leases. There are a few different types. First, there's the area gross-up. So your tenant client occupies, call it 5,000 square feet of real space when you measure from the outside wall of exterior walls, outside edge of exterior walls, to the outside edge and to the inside of the, or the center line of the wall that they share with a neighboring tenant, and so on. The standards that people throw around are BOMA and SIOR, and in the retail leases you shouldn't see references to BOMA too often. You likely see GLA and weighted GLA and adjusted GLA. What happens there is in the office setting and sometimes industrial, the space that the tenant actually occupies is grossed up by the area of common corridors and washrooms and so on the floor. The rationale being that if the landlord leased the entire 20-story office building to single-floor tenants, then it would recover rent on every single piece of space on the floor except for the elevator shafts and the mechanical rooms, but it would recover rent on everything else. So why should the landlord recover less rent or from less area if it multi-tenants the floor? So what happens is that tenants of a multi-tenanted floor share a part of the area of the common corridors, and that's how they achieve the gross up, and it should be proportionate. The BOMA standard achieves that. Now there are two BOMA standards, the old one and the new one. And the old one, which is a 1980 standard, most people refer to it as that, although it's also 1989 and 1990, those are all the same standard. The BOMA standard calls for a gross up by just the area on your floor. The 1996 standard calls for a grossing up by the common areas on the floor and the other common areas in the building, like the lobby and conference facilities and daycare facilities and that sort of thing. So it's a substantially greater level of gross up. And it's been challenged on a business level. Many tenants are refusing to pay it. And some landlords are moving over to the 1996 BOMA standard, even though it's already 2004. They haven't moved over it to it completely. But some landlords have moved over to it on the basis that they'll make it revenue neutral. So when your tenant client comes in and says, I've been a tenant in this building for 10 years, my area has always been 5,000 square feet. Now suddenly I'm in the same space, but all of a sudden it's 6,000 square feet. What you need to try and figure out is, did the tenant negotiate its deal on the basis of 5,000, then did they work the numbers back to make them apply to 6,000, or did they negotiate the deal on the basis of 6,000, in which case the tenant's already signed up for gross costs that incorporate that extra gross up. On the retail side, there isn't that much of a gross up, but there can be a gross up for the pop-out area of the storefront where it goes out to the imaginary lease line in the corridor on the theory that the people who mill about in the storefront area are the tenant's customers and nobody else is using that area. And so that is rent that a space that the tenant should pay rent on. On repair responsibilities, what you may want to try and trim back are exposure to capital expenditures like HVAC replacements. And on pages 12 and 13, I gave you some ideas there. The phrase capital repairs, tenant not responsible for capital repairs, it's not very useful because capital just means anything that produces an asset of a long-lasting value. And a small HVAC component may be a capital item, may not be very expensive. Another one may not be capital, may be very expensive. So for an ordinary tenant, I think the exceptions you should try and achieve are the ones that are on top of page 13. And I'm surprised at how many times tenants get away with the exception for damage by fire, lightning, tempest, and other items insured by the landlord. That is so contrary to the net lease concept and contrary to the risk allocation provisions in the lease. Yet tenants throw that in repair along with an exception for reasonable wear and tear, and it often flies through. So you should try it. You also want to spend a little time looking at, and just a little time, because your retainer isn't forever, what is the tenant's responsibility in damage and destruction. Quite often the damage and destruction clause says that the landlord and tenant will repair as set out herein. And then there's nothing set out who repairs what. And so because it's a net lease and elsewhere it says the tenant repairs the premises, it may be that the tenant repairs everything. And that may be contrary to the financial underpinning of the deal. Now, on the other hand, the tenant should be prepared to insure its improvements and replace the improvements. But the shell and the basic structure of the premises should be provided by the landlord. Sometimes you may get away with a landlord having done pre-term work, and the lease says that the landlord will repair on damage and destruction to the extent of the Schedule C pre-term work, which is great. So don't touch the clause, go on to something else. Sometimes tenants are surprised to learn that when they're interrupted in carrying on their business in the premises, they have no claim against the landlord. And you should probably just educate your client to that fact. They should insure. It's very unlikely that you will achieve a clause in the lease that says if the tenant can't access the premises because there's a power outage, that it's entitled to a rent break. You might be able to get the landlord to agree that if it's going through some sort of redevelopment and it powers down the utility lines, and so it's the one who's causing the disruption, that then the landlord will pony up for a rent break. And for the most part, the damage and destruction clauses only talk about the tenant's entitlement to a rent abatement if the premises are damaged. You should broaden that so that if the premises are damaged and inaccessible, or damaged or inaccessible. In other words, customer access or if it's an office lease, access by the occupants is not available, then the mere fact that the premises are intact doesn't deprive the tenant of at least the rent relief. And the rent relief is often expressed to be just minimum rent and not additional rent. But it should be all three. Most landlords, percentage rent too, most landlords insure for all. Now, property taxes. Apportionment is the place to focus some of your efforts. You may see some excesses in the definition of realty taxes. They'll charge you an in-bin fee. They'll charge you the costs of appraisers or consultants who contest taxes. You should expect to pay the cost of the consultants who contest taxes. But you should not expect to pay an admin fee on top of taxes. So try and strike that. The apportionment issue is about whether the tenant would pay on the basis of what it likely generates in terms of an assessment or a proportionate sharing, which is basically as a result of square footage. Now, the current value assessment method by which taxes are developed calls for an assessor to come up with the current value assessment on an income-producing property. They largely look at the rents that the building is able to generate, and it's generally understood that anchor tenants in a strip plaza, the grocery store and the drugstore, and if there aren't any department stores around anymore, but if those are generally likely to generate less income per square foot than the inline tenants, also known as CRU tenants. If you're representing a hairdresser CRU tenant, then you're probably going to get stuck paying a proportionate share, and that means you're basically subsidizing what the taxes would be that the grocery store and the other anchors are generating. If you're a pad site tenant, I see some in the audience here who represent some Wendy's locations, a pad site tenant can often get the landlord to agree that even though there's no such thing as a separate assessment anymore, the taxes will be apportioned to the tenant on the basis of what the unit itself generates. And so we look behind the assessment to the notes that the assessor has. Now, a small landlord who doesn't have a department likely won't be interested in that sort of an administrative effort. Grossing up on realty taxes, if you have a building that is not fully occupied, the vacancy credit that the landlord is entitled to, reflecting former business taxes, should go to the landlord's pocket, not the tenant's. So you may be surprised to see a clause in the lease that says that the realty tax bill will be grossed up to the amount that it would have been had the building been 97 or 98 or 99 or 100% occupied. That's not wrong. That just ensures that the taxes actually are attributed to the people who generate the taxes, the ones who are in there and who are occupying. The vacancy credit will therefore belong to the landlord. If you're concerned about it, what you can do, most landlords will agree to it, is ensure that there's a protection against the landlord recovering more than 100%. It shouldn't recover more than 100%. And I've given you some examples of how to phrase that. There is a concern that there will be in the future some non-assessment based taxes, and those would be, user fees for garbage. There'll be some parking taxes coming apparently. Those will be probably allocated by landlords on a proportionate share basis. I think a true proportionate share basis is the correct way of allocating. On the weighted GLA business that we discussed earlier, one of the elements of that is the proportionate share denominator often excludes the anchor tenants. And lately, there's a creeping tendency to describe an anchor tenant as anybody over 7,000, 8,000, 10,000 square feet. They're not that big. And what that means is all those other tenants are subsidizing not very big tenants. So if you're representing a retailer who's going into a shopping center that has some 2 or 3 known anchors, then you might agree that they are going to be excluded from the denominator, but that the landlord can't amass all of the other CRU space and consolidate it into big 10,000 square foot units and leave your tenant with being the only one left picking up everything that is not allocated on a CVA basis. The restoration and make good clause in the lease is very important. You should look for the tenant not being required to remove leasehold improvements on leaving the premises. I didn't mention in the paper excess usage of HVAC for office tenants. They often pay a charge for coming into the office on a Saturday or a Sunday and using HVAC. You can try to increase what they call the normal business hours. That your tenant would be appreciative of that. And the last thing I think you should look at is the relocation provision and ensure that it doesn't put the tenant to any cost and that it protects the tenant from any disruption. But you shouldn't try and resist the relocation clause in most circumstances. So I'm hoping that's useful for you in arriving at your top 10, and I'll be around later on in the day to answer some questions.
Yes, Natalie will be at the question period this afternoon. She's also going to be invited back next year to do part 2 of this presentation. We're going to take a 20-minute break and come back in about 1:45. Thank you.